Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And this year, starting off the podcast, we're going to have on Andew Branan, and I'll turn it over to that interview here in just a minute. But Andew is the Assistant Extension Professor of Agricultural Law in the Department of Ag and Resource Economics at the College of Agricultural and Life Sciences at NC State University. Andew is an attorney who concentrates on ag, real property, and natural resource law with a focus on farm and land succession. He's been in private practice before coming into this position, but he's been there for a few years and has done some research and looked at sort of the ongoing North Carolina hog farm litigation. I shouldn't say ongoing, it has been settled. So I had him on to talk a little bit about the Fourth Circuit's opinion and a little bit on the settlement. And more than likely, once some other state things play out in the state, we'll have him on again to talk about their right to farm law challenge that is currently ongoing in the state, looking at some of the amendments if they're constitutional or not. So have Andew on later to talk about that once that sort of plays out. So I will now turn it over to myself and Andew. And I need to point out this was recorded late in 2020, so not all sure what additional things have happened since then that we might be talking about. But we're mainly focused in on the hog farm litigation. So I'll turn it over to that. Thank you. Hello, everybody, and I will let our guest today, Andew Branan, who's a faculty member at NC State, introduce himself and tell us a little bit about what he does at NC State.
Sure, Paul. Very much appreciate the invitation to come on today. So my name is Robert Andew Branan. I go by Andew. I'm an extension assistant professor in the Department of Agricultural and Resource Economics at the College of Agriculture and Life Sciences at North Carolina State University. And my role there is twofold. I am faculty in the department, and I teach two courses, one on environmental law and economic policy, and another on agriculture law. And then the other part of my job is with the Cooperative Extension Service, working with all 100 counties in our state and the residents therein, landowners, farmers, on educating them on various legal matters relating to farm operations, to land management, land use, zoning, nuisance issues. It's a broad portfolio of topics.
Mr. Say, and nuisance is why you're here today, because we're going to talk a little bit about the hog farm litigation that's gone on and recently been settled in North Carolina. So why don't we start off with, you probably know better what's going on in North Carolina than most of us do. So what has been going on with the litigation, and what is the right to farm law like in North Carolina, and what exactly do right to farm laws do generally?
Sure. And so, as a little bit of background to the cases. So the cases that we're discussing today concern the integrated swine production or pork production industry here in North Carolina, and how that's structured, and really the question of whether the environmental externalities of this system rise to the common law standard in our state of a nuisance to neighboring property owners, how the operations are managed, and specifically how the waste management systems in those for those operations are managed, and the impacts on neighboring landowners' property right of quiet use and enjoyment. And this has been an issue for some time. This is one of our most economically important agricultural production sectors in North Carolina. It is largely concentrated in the lower coastal plain around in the counties of Duplin, Sampson, Bladen, Wayne County, those areas down there. And there's been a lot of literature over the years about the impacts of the system and whatnot. But on the other hand, it is an extremely economically important system to our state in terms of jobs, in terms of agricultural production. And so it's been a very challenging topic. Well, it did come to somewhat of a head in 2014 when nuisance cases were filed in Duplin, Sampson, and Bladen County. I think I have those right. And at the end of it, after these, it resulted in 26 separate cases representing around 500 plaintiffs. And again, these were in Duplin, Sampson, and Bladen counties. And the cases originally filed in state court were removed from state court and later filed in federal district court on diversity grounds, because the plaintiffs are all North Carolina residents and the defendants, which are Murphy Brown LLC, is a resident of Delaware, and Smithfield is domiciled in Smithfield, Virginia. So you had what we call diversity in several federal civil procedures. So a federal court could hear a state law nuisance claim. And these cases resulted in verdicts against Murphy Brown and Smithfield, and the verdicts were a combination of compensatory damages, essentially compensating the neighbors for the damage to their right of quiet and enjoyment of their property because of these waste management systems and their externalities, but also punitive damages against the integrator, which would be Murphy. I'll just say Murphy Brown / Smithfield for the condonation of using this type of waste management system. And so the juries in these cases, there were 6 verdicts, I think 5 verdicts came back with a combination of compensatory damages, but multi-millions of dollars in punitive damages. And that was one of the big issues on appeal when these cases were appealed to the Fourth Circuit recently. One of the big issues in these cases is our state right to farm law, which was originally passed in 1979. It was one of the first in the nation, which all 50 states have some form of right to farm law. And the original intent, or the essential nature of these right to farm laws, is a codification of a defense, a legal defense against a person who is supposedly committing a nuisance called coming to the nuisance, meaning that you have an operator, somebody that's operating, whether it's a cement plant, whether it's a rubber plant, whether it's a farm, and they're just operating, and someone moves in next door and then complains about it. And so that's normally a defense in nuisance actions, but our right to farm law is the codification of that defense. It has been updated at least 3 times since 1979, one in 1992, next in 2013, and then in 2018, largely in response to developments in nuisance cases throughout those years. And for example, the North Carolina General Assembly in 2013 amended the original right to farm law following a case called Durham v. Britt, which concerned whether conversion from a turkey farm to a hog farm constituted what was known as a fundamental change. The right to farm statute said that you cannot bring a nuisance action just based on a fundamental change. And in that case, the Court of Appeals said that, well, that's actually a question for the jury, whether or not such an intensification of operation is a fundamental change. Well, the General Assembly following that case, some years following that case in 2013, went ahead and codified, what is not a fundamental change, meaning change in technology, type, size, ownership. And so I teach that to my undergrads and talk in extension about it as, a general legislative responsiveness, given the importance of this particular industry, when a common law threat like nuisance comes up, how to better protect the industry from those types of. And so the most recent amendments to this law, to the right to farm law, came following these nuisance actions being filed. And so that bubbled up. They were filed first in federal court, and then some months or a year or so later, the General Assembly amended the right to farm law to further tighten, who may bring the cases and how much damages they can get. And so that became those amendments to that law became one of the central issues in the Mccreever case, which was the main case, the case on appeal before the Fourth Circuit. And so that, again, that was legislative responsiveness to this type of threat. These amendments were passed and as part of a package of amendments that our General Assembly does on several statutes related to agricultural and land use management. But these specific amendments did several things. First, they limited the amount of damages that a nuisance plaintiff can receive, and they limited the damages strictly to the diminution in property value or the rental, the purchase value or the rental value of the property. So that was one. The second was the statute imposed a shorter statute of limitations for when a plaintiff could actually bring a nuisance action, shortened it down to 1 year, which is less than the normal 3-year statute of limitations for a common law nuisance or trespass claim. And then the third was to limit a plaintiff could not bring a case if they were greater than 1 mile away from the offending nuisance. And so, meaning that in this particular case, that if you lived more than a mile from the hog lagoon or the hog house or whatever was being claimed to be the nuisance, you could not bring the case. You were limited. So, but one of the big issues that came up in one of the primary issues in this case before the Fourth Circuit was whether or not those restrictions, which were passed after the cases were filed, whether they applied retroactively to bar these claims.
And I think that leads into kind of my next question, which is if we look at, because the Mccreever case, I believe, is which one it is, correct?
Yeah, Mccreever.
Mccreever is the Fourth Circuit decision that came down late November with the 3-judge panel looking specifically at that right to farm law issue. So how did they handle with the change in the right to farm law in applying to these plaintiffs?
Sure. The main issue regarding the right to farm law, that I read was it concerned the damages award, because recall that the bulk of the verdicts, the damages verdicts in these cases was punitive against the corporate parent. And I forgot to mention that an interesting thing about these cases is that the plaintiffs did not sue the farmer. The farmers were not sued. Only the integrator, the company that processes the product, because all these farmers are on contract with the integrator and operate these waste management systems, these hog farms and waste management systems, but they were not named in the case. And that was actually another issue in the case about whether the case should have been dismissed because they weren't included, but the Court of Appeals found that no, that was okay, that the case proceeded without them. And so, in other words, the plaintiffs went directly to the parent, to the contracting company, rather than the farmers themselves. But the issue was the damages, that these verdicts should not have stood because this new right to farm law says that you can't have punitive damages against, that it's limited to property values only. And so in order to bring this in, the Murphy Brown Smithfield, I guess I'll call it the appellant, their main argument was that the General Assembly, when they passed the law in 2018, or when it came out as the Farm Act of 2018, that the General Assembly intended that this law apply retroactively, just as a matter of clarifying its right to farm purpose, the protections purpose of the original statute. And the actual title of the statute was, or at least that the amendments to this particular statute, was an act to clarify the remedies available in private nuisance actions against agricultural and forestry operations. And so the court responded to that issue on several fronts. First, really first and foremost is the court looked directly to the language in the right to farm statute, which said specifically, and I'll quote it, this act is effective when it becomes law and applies to causes of action commenced or brought on or after that date. And so it said right there in the language of the statute, this is only a prospective amendment. It only applies to future cases, not anything that's happened in the past, or that's been filed already. And Judge Thacker, the judge who wrote the opinion, he said that, while we cannot ignore the act's title, because that was one of the arguments that Murphy Brown Smithfield made was look, it's right there in the title. They're clarifying this, and there is North Carolina precedent to support that contention that a clarification of a statute to make it more, I guess, to clarify an ambiguity can be applied retroactively. But Judge Thacker said, while we cannot ignore the act's title, it does not control as compared to the operative text of the statute. So the statutory language was what controlled. The court also, as a more practical matter, referred to some precedent, which actually cited a 1908 U.S. Supreme Court case that there's just a strong presumption that statutes, when passed, cannot operate retroactively. It's not impossible, but it has a measure of impacting a vested claim a right, so to speak, that's already been vested in a plaintiff, that the legislature, it's just frowned upon, can thereafter invalidate that vested right or vested potential right. And lastly, the court said that, if you really look at the right to farm statute and you look at the argument being made that a clarification should just bring an ambiguity more into focus, what really happened, though, is that this clarification introduced a whole new thing into the right to farm law. So up until 2018, the right to farm law was primarily concerned with who could sue, how far away, how long you've been impacted by the nuisance. I'm not recalling whether there was a mileage limitation or anything like that in previous law, but it was just, who could sue, the neighbors. Well, this clarification introduced a new concept in terms of how much can you sue for. So it wasn't clarifying something that was already there. It was clarifying, it was introducing something new. And the court said that that this is, that's not what a clarification is. And so the court rejected that particular argument.
And I don't know how much you want to pontificate on this, but do you think the old law how do you think the Fourth Circuit would have handled the old law prior to the clarification in this?
Well, that's a good question. I think and Judge Thacker, in the opinion, he addresses that directly. And if I'm recalling, because I have the case up here, but I'm recalling in my reading of it, that I believe Judge Thacker noted that even the appellees agreed, the plaintiffs in the original case agreed that we filed these cases after, I guess it would have been July or October of 2018. I'm not sure the effective date. They would have been out of luck that this statute would have controlled. So going forward, and this is is it what Judge Thacker is saying, and we don't know this because this would require a future case and a future argument, but is saying that had this case been filed afterwards, then we wouldn't be here discussing or we would be able to dispense with this issue pretty easily.
And then I think the other interesting issue, and there are really three issues in this case on appeal, but to me, the expert witness issue is more for legal nerds to kind of
Yeah,
debate and talk about, and not that's something that a normal producer is going to care about because they don't really care how an expert witness gets qualified for court. They just want it to be qualified if it's
right.
them. But we do have, you like you've talked about, there's this punitive damages issue, that there were high punitive damages in this case. I can't remember what the highest one was, and they are capped under North Carolina law to an extent. How did the judges handle the exact issue with those punitive damages? Because that was another big contention in the appeal.
Yeah, and this is really the again, it's a fascinating case, but the punitive damages are from the verdict standpoint, the liability that Murphy Brown Smithfield was exposed to in the verdicts, the financial liability, it was the punitives by far. I'm looking at the Mccreever, the overall verdict was 51 million. I think the compensatory damages were limited to $75,000 per plaintiff, and so that shows you how big the punitive damages were in the verdict. And as you mentioned, they were reduced down to 3 million because of another North Carolina statute that limits punitive damages in such cases. And so yes, it's a pretty big deal. So first the court, the issue primarily was, well, let me deal with the vicarious liability issue, because one of the issues was, well, wait a minute, Murphy Brown is just the contractor, or the, Kinlaw Farms, which is the farm at issue in this particular case. Murphy Brown Smithfield is arguing, and they're justified in this argument, is like, we're just contracting. How can we be held vicariously liable for the management of these waste management systems? Because they're not there on the farm every day doing all the the acts involved in hog farming. And I'm bringing this up because it leads into the punitive damages that Judge Thacker, in the opinion, sort of pulled apart that position that, well, yes, normally you cannot have punitive damages against a contractor for the person who contracts with another for the acts of the other person who does the actual act. Normally, and North Carolina has a statute that says no punitive damages in that case, except when there's willful and wanton behavior and the contracting party is aware of it. And so Judge Thacker went through in some detail, citing the evidence of how this was something that was by far out there in the public domain. And there was specific evidence that Murphy Brown Smithfield had files of all of this. They'd been monitoring all of this, just rightfully, over the years. These studies, whether or not they agreed with the studies or not, the studies were there. And so the court attributed an awareness on their part that, as an exception to not being held vicariously liable for punitive damages. So essentially, the court said, you were aware and you condoned these practices, and the practice is termed as a lagoon and spray field waste management system, and it's the standard. It's what most operations are under. And so because that was tolerated in the contract arrangement, and the knowledge that particular system had some problems or reported problems, that Murphy Brown Smithfield could be held vicariously liable in regards to punitive damages. Well, in regards to the punitive damages themselves, Murphy Brown Smithfield wanted to bifurcate the trial because on the evidence of the wealth of the corporate parent of Murphy Brown Smithfield, and this went to two issues. One, ability to reduce the nuisance, and that's something that's actually discussed in the restatement of torts about feasibility, whether when you're balancing the harm to the plaintiff versus the utility of the nuisance offender, one of the factors in there is like, well, how much of a burden would it be on the nuisance offender to do something different, to do something that reduced the nuisance? And so the two issues with the punitive damages were, one, as allowing that evidence of the wealth of the corporate parent to go to the jury for first liability, and then the other one was ability to pay. And so, and here's where we have the split in this case, where the Murphy Brown Smithfield lost most of it, but won on this particular note. They lost on the part where this evidence of corporate parent wealth was allowable to the jury to find Murphy Brown Smithfield liable, because there was evidence that that they could have afforded a better technology, capping the lagoons, doing something different, which is more expensive, but still the issue there was, well, it's relevant that they could afford to do this. And I'm using the court's language, or paraphrasing the court's language. And so the Judge Thacker said, yes, that evidence was suitable for the jury to hear that, because that's relevant when you look at the elements of the utility of the conduct of the offender. It's one of the elements in the restatement of torts. And so that was allowed. On the other hand, though, the court came down and said, for the purpose of ability to pay, meaning, hey, these punitive damages, not that big a deal. You've got the money. That was a different matter. And so the court has remanded that back, or did remand that back, for rehearing on the punitives in terms of ability to pay. And so that's where Smithfield, or Murphy Brown Smithfield, essentially won on that particular issue, which as I mentioned in a few minutes, is now rendered moot because they settled the case the next day. Judge Agee, though, if I'm pronouncing his name right, I'm not sure, he dissented in the case and said that neither should have been admitted, and the trial should have been bifurcated in regard to the punitives. And so, but he was one out of three. So, so the opinion stood.
And that kind of leads into my next question with where are we now? And you've kind of already mentioned where we're at now.
Yeah.
We got a settlement. So
within hours, it seemed. Yeah, this. I think the opinion. I remember the opinion came out at like 4 on a Friday, and I think by Monday the next week they had settled. And
it seemed like by 8 a.m. we all had the email saying,
yeah, right,
settled.
So it's now moot. So this won't be appealed to the Supreme Court. Yeah. But yeah, and I don't know much yet about. I have some contacts on the defendant side that I know they can't. The settlement's going to be confidential, so there's going to be very little we can know about it. But I don't know yet. My assumption is this covers all the cases, and so yeah, we don't. But Murphy Brown Smithfield made the financial calculation that, okay, punitives can stand and as regards to liability. So what the plaintiffs walked away with, more specifically what their lawyers walked away with, we don't know. But it's now, at least in terms of these cases, it's a dead letter. And as I think we talked about just a few minutes ago, moving forward, because this case somewhat stands for the proposition that, yeah, the new right to farm law, it's passed by the will of the people, by the legislature, to protect this economically important farming industry, though many people argue that it really just focuses on the swine production industry, but it certainly could be applied to poultry as well. That moving forward, for these types of cases, the damages are going to be strictly limited by the new right to farm law, or the right to farm amendments. So I think this, as a practical matter, it makes these types of nuisance cases much less attractive to private lawyers, because property value diminution is in the tens of thousands of dollars. That's just not that financially attractive to invest, type of case to invest in on a contingency basis. But I think the case was, there a number of things in the case, and I guess you and I are, we're right to farm geeks and nuisance geeks, and so the proposition that the case does stand for is that, in operation of these systems, of these waste management systems, the systems themselves, the construction of the system is not the nuisance per se, the way I'm interpreting that, meaning that the statute of limitations starts to run from the time that you establish the system. What the Fourth Circuit was saying, Judge Thacker was saying, is that no, this type of nuisance is a recurring nuisance, meaning each time you do anything in managing the system, each time you spray out on a field, spray the slurry out onto the field, or applying to poultry, you spread your litter. Whenever you have to deal with dead carcasses and trucks come in and make noise, these are recurring nuisances. So the statute will always begin to run each time a truck rumbles in at midnight, or flies come onto the property, or smell comes onto the property. So I thought that was pretty important. And so, I think how this impacts the poultry industry, I think a lot of that's going to come down to waste management technology. This case was very specific on hog farming and the challenges faced by the lagoon and spray field waste management technology system. And so how that translates over to poultry system, I don't really know yet. It's probably going to be more applicable in wet poultry waste management systems, but I don't know how specific it would apply to dry poultry management systems, but it's the door is opened. But again, at least in North Carolina, the damages issue is now so restrictive. I think it's going to be harder for plaintiffs to find lawyers to bring these cases unless they're paying as they go, which is not going to be normally the case. And I guess I'm sorry.
I was going to feed off on that before you give your closing thought. Is the one thing we work with poultry growers here is to be good neighbors. And I think the other thing this case stands for is it's not only the grower needs to be a good neighbor, the company needs to be a good neighbor, because the company's sending the trucks in at these early morning hours. And was a problem here, to where if you're at least considerate of the people living around your growers, you might stand a chance in some of these lawsuits where they might not be able to recruit a plaintiff's pool as big as they did here in this.
I agree with that. I mean, there was a lot of the language devoted towards, as Judge Thacker noted, that that Murphy Brown Smithfield testified that it told Kinlaw Farms, the farm in this case, don't do this when the neighbors are having a wedding or a picnic. And whatnot, but nonetheless, Murphy Brown never stepped in to stop it or to do anything, and they're the ones really scheduling the trucks.
Yeah,
I'm not sure of that, but I think the issue of trucks running from 6 p.m. till dawn in one case, that's going to be something that the company is obviously involved in because they're driving the trucks. So it sends a big message about the corporate parent responsibility. And I guess my last, the last interesting, there's a number of things in this case, but the concurring opinions, I mean, particularly Judge Wilkinson, his opinion's his concurring opinion is definitely worth a read, just to get a sense on how a judge sort of goes off, I don't want to say off script, but just somewhat editorializes about their feelings on matters of environmental justice, which is, Judge Wilkinson, he was looking at this case as an environmental justice case, saying that you wouldn't have this case had it been brought in in a county that with more wealthy neighbors. You wouldn't have a hog farm there in the first place, or that they would have successfully prevented the landowner operator from setting that up and getting that contract. And so he goes full on environmental justice with the concurrence, and it's worth a read, just at least get a window into, how far a judge is willing to go in terms of addressing that issue in relation to these systems that we work with in poultry and swine. And really the at the end of it, I guess my closing comment would be the big real question is well, the judges actually note that, we could have an alternative to this system. There's pasture pork. Yeah, well, the question is like, how do we produce chicken and pork at the level that we're accustomed to as a society now? I mean, the utility of bacon cannot be argued with. Without this system, we can't just walk into Food Lion or Harris Teeter and pick up as much bacon as we want. In fact, if I can say this, when I gave a presentation on this topic to the Bar Association last year, and I was out in the breakfast aisle, and they have the buffet set out there in the hallway. It sounds alien now, of course, right? But we're all there, and there's a big bin full of bacon, and so I was like, well, I got to give a presentation. How am I going to start this? I got a coffee cup, filled it with bacon, and when I got to give my presentation, I put that up on the rostrum to say, this is what the issue is. It's like my ability to fill a cup up with bacon wantonly, and how is that going to be produced if not through this system? And so, because talking about pastured pork, it's not really it's like, what would the environmental degradation of thousands of small, herds of swine, what would that be like? And we don't have the processing infrastructure to process a genetically diverse animal herd. It just doesn't exist yet. I know COVID-19 has created somewhat of a spur for more small processors, but we're just not there. So I raise that issue. It's like, it's really going to come down to the tech.
And here it would be I would fill it up with chicken wings.
Right. Yeah. Well, chicken wings. We didn't have chicken wings before 1979 or whatnot. We didn't have the McRib before these systems were created. So it's again, this is very important to the families involved in this, whose financial lives are bound up in all of this, and it's a very challenging issue, and we'll see where it goes from here.
Yeah. Well, thank you for coming on today, and look forward to seeing what happens into the future based on all of this. Hopefully it's slightly less the issues in North Carolina that you've had here recently.
Yeah, Paul, I very much appreciate the invitation to come on, and have a good holiday, and good luck in wrapping up your course. Thank you for listening to this episode. I've put Andrew's contact info down in the show notes, his email at least, so you can get in touch with him if you have any additional questions on this episode. If you have any thoughts on what additional episode things we should be covering here, please let me know. You can email me, you can tweet me, my contact info is down there as well. So please let me know. But thank you again for listening, and enjoy the rest of your day.